All right. Viva's looking at the camera, and we are completely set. We have Viva Frei, and first time to the channel, so he's got to spend time introducing himself. Good Logic. Tell us about yourself, Joe.
Hey, how are you? Hi, it's Joe Nierman. I am a New York attorney. Been practicing for 21 years since I was admitted to New York in '99. I'm a solo practitioner, and I used to say that, label myself that I'm a big believer in the values of MAGA, but I think it's actually probably more appropriate to say that I'm just a huge believer in basic American values. And I have to thank the fact that I'm here. I have to thank 5 people before I go any further. And those 5 people are first God. I want to thank because God gives me more blessing than I deserve. I want to thank my wife, who's crazy for not like ripping my head off when I told her I want to invest my time doing this sort of thing, because I think we all know our spouses put up with a lot of belief in us. I want to thank Ron Coleman, because nobody would have heard of me if not for Ron. I can get into that later. I don't want to spend much time. I want to thank you, Eric, for bringing me on here. Nick, because nobody would have heard of me if not for Nick Rekieta. He actually found my videos because Ron Coleman, who actually I sit in synagogue behind him, didn't even know that he was this internet lady until ago. And the other person who doesn't even know it is indeed that guy right up there, Mr. Viva Frei, because you, sir, inspired me to. He inspired me to actually that this is something that I saw what he was doing. I always liked his work. I thought he did great work, and I was like, I was envious. I was like, this is something I always felt like I could do, and I'd be like, people would like the content I would produce, and I was like, you know what? He's a smart guy, he's a smart attorney, and he's doing it, and I think I provide something that would be similar yet different enough that I'd be contributing to the world at large. And here I am.
Cool. So David is the Joe Rogan of legal podcasting.
Actually, I was just fishing around Joe's Twitter page, and his pinned tweet says, "Viva, I'm a huge fan. You've inspired my channel more than you know. I remember a video you did attacking Legal Eagle strawman arguments in impeachment 1.0." So I just replied, said I didn't attack him. I critiqued what I thought was a bias that affected his ultimate assessment, not just of the impeachment, of Captain Marvel. And I say, attack is a very loaded word, but yes, when I perceive bias that I think affects the outcome, I'll call it out, and I expect people to call it out in me as well.
Oh, I will say I attack Legal Eagle.
Well, I was saying, YouTube. If for anybody who doesn't know, we'll talk about this. They took down PewDiePie's Coco thingy video, and one of the reasons they took it down was harassment or bullying of other content creators. So I want everyone to know, in the legal world, you're supposed to have thicker skin, and you're supposed to be able to deal with critique when you put out analysis. But yeah, there's also in the legal community, attacking someone for an argument is different than unleashing 100 million 9-year-olds on them.
Well, perfect. And on that theme, we got Nick. You got to do a quick introduction.
Oh yeah, hey, what's up, guys? I'm Nick Rekieta of Rekieta Law, small law firm in Central Minnesota. I do live streaming here on YouTube, and I talk about legal topics, and I make fun of people, and specifically people with fake law books in their background when they sit in front of a green screen and pretend to be in a law office. I make fun of those people, and doubly so when those people suggest that a touching of a map that someone is holding is justification to break their arms, steal their clothes and their motorcycle. I think those people are insufferable idiots. But that being said,
but he can come on the channel anytime on any of these panels. I would love to have you on, Darren.
I would say I would
Devin.
Yeah, him.
I would have him on, and I would maybe even be prepared to turn off the chat, if only as a welcoming reward, because the chat can be vicious. The chat's vicious with me. I mean, if you say something that they don't, the crowd doesn't like, they'll let you know. Some people are more open to dealing with it. I have no problem with it. Others, I can imagine and understand being more sensitive.
Well, Nick's is a whole nother level. And by the way, on the theme of the week, I wore my new shirt.
Yeah.
which I figure is appropriate
Oh.
with my current company. I'm
Nice.
watching for the yellow as we speak. Every time I've had Viva on lately, usually within a few minutes, goes pink. I have the other screen up, so it's the countdown to yellow. So anybody who wants to contribute, awesome. Or better yet, just come on to the Locals channel. I think everybody here is on Locals now. And
Yes.
I'm at unstructured.locals.com. That's vivabarneslaw.locals.com, goodlawgic.locals.com, and rekietalaw.locals.com.
Yes, sir.
All right. So there's a whole suite. And the more creators that can get on there. I mean, I don't just want people to, hopefully follow us, but I want every creator out there to get on, because then that'll entice more people to just hang out in there and have a cool feed.
It's up and coming. It's a great platform. I mean, it's more convenient than Patreon, and there's less maintenance than with Patreon, and it's more interactive.
Yes,
for sure.
And these are the good old days of YouTube. We don't even realize these are the good old days, because we'll look back at this period, I expect a year or two from now, when we're not even allowed on here anymore, and we'll be like, what happened? But that's unless we save the internet, which is what I plan to do with you gentlemen today. So if you allow me to, I think we can save the internet.
Oh, okay. Hey, we'll boil one ocean at a time. Perfect.
Yeah.
Nick, what
Yes,
happened? You're you see your second channel. You just seem to be causing problems.
It's my third channel. But yeah, my archive channel for live streams got a strike because I covered day 3 of CPAC and Donald Trump spoke, and YouTube was not happy with the fact that Donald Trump spoke. I'm not the only person who got hit, and they have attempted to scrub his CPAC speech from the internet, the full speech. No, the Right Side Broadcasting Network got hit, and they got a two week ban, because it must have been a second strike or something like that on their channel. And I believe that they have, according to there's a Twitter account that follows these sorts of things, and they said that they've taken down the full speech, so now only snippets are available. The funny
that CPAC themselves doing it.
What was that?
No,
I bet it's CPAC themselves doing it, because this sounds like some copyright BS. Like
it's
they want to
guidelines.
hold all of it.
I don't think so. Someone sent me an article. I haven't read it fully through yet, but it was that they're taken down for repeating that which was not allowed to be repeated on the internet anymore. So
yes, Donald Trump advanced claims
Lord.
about an event that happened last year in November, and
we're talking about the JFK assassination anniversary, guys. Not that thing in Dallas that went down. No, nothing else.
So that's what was hit on my channel. I'm still waiting for more clear answers, because I just want YouTube to put down, did I say something, or was it just the content of what Donald Trump said? Because we need to know, as creators, if we're disallowed from covering an event, we need to know so we can let people know where that event can be covered. But the funniest part of this for me is they struck it on my archive channel. It also had a copyright claim and was age restricted before it got shut down. On my main channel, the live stream of it is public, monetized, and no strikes.
Eric,
wow.
Nick, don't jinx it. But
I was gonna say
it's preposterous, because this happened to me, Nick. I did a live stream. The live stream was green lighted. It was manually reviewed and green lighted. Then I post segments of it, unedited, unaltered segments. One of the segments gets demonetized. I was like, okay, fine. They remonetized the stream. Obviously, they're going to remonetize the clip. They confirmed demonetized on manual review of the clip. Then I get on chat and I say, whoa, guys, you remonetized after manual review of the entire stream. And then they write back, oh, yeah, well, now we've gone and demonetized the whole stream itself. I mean, it is preposterous. And then they give you three reasons, some of which are not necessarily mutually incompatible, but it's like, just in case this one doesn't work, we're giving you copyright strike. In case that doesn't work, we're giving you terms of service violation. And in case that doesn't work, here's a your video's been claimed by CPAC. I don't know if that happened, Nick, but it is preposterous that we are actually living in a world where they're deleting. This is not the anarchist cookbook, how to make things at home type stuff. This is it's
Well,
preposterous.
it is how to talk about facts that are uncomfortable at home. So maybe it is the new anarchist cookbook. I mean, maybe that's where we are. I went on a drunken rant last night about free
And
speech.
what was it? A day that ends with Y?
Yeah.
I'm
No,
serious.
it was particularly ranty because I'm so tired. I was talking about Amazon versus Parler, and they've refiled in Washington court, and they've fixed so many mistakes that they had made in their district court filing. But I was talking about the judge in Washington, or in the district court filing, because part of the reason that she didn't grant a temporary injunction on this thing and allow Parler to actually live, because I mean, I'm of the opinion that it's basically dead now, even though it's back. But part of the reason she didn't grant the injunction is because she said that that speech that was happening on Parler was putting the public at risk more for incitement, more than Parler was at risk for going out of business, which is one of the most ludicrous things I've ever heard a judge say, to suggest that there might be some speech that may rise to the level of incitement on a platform. And I'm not aware of any single tweet ever being prosecuted for incitement, because it's so far outside of the scope of how incitement works. So to say that some sort of tweet on Parler might rise to incitement, therefore we must shut it. We must allow it to be shut down because the balance of equities tips against it because of that. And it's like, the whole purpose of the First Amendment is to protect speech that comes as close to incitement as possible.
Well,
that's the most important speech.
Yeah, I mean, Larry Flint, I hate to say, we lost a lion of free speech a couple of weeks ago who repulses almost everybody who's ever heard of him.
Yeah.
But you need the Larry Flints out there to actually push free speech, or you're screwed.
Yeah, I agree.
Everyone.
Go ahead, Joe.
Joe, you got to go because there's a lag before you start talking. So everyone stop. Joe.
I'll start talking early, and that way it'll come in right in the right time. So I think everyone thinks we need Section 230 reform, and that we need to fix it in order so that we can free up the internet and make sure. And Nick, actually, and you guys, all three of you involved in the panel, I think, with Ian Corzine and Allison
Morrow.
Something. Like a month ago, where you were talking about, Alison Morrow, thank you. So you were talking about how to fix the problem. And I think a lot of what Nick said, I agreed with, where he was talking about the distinction between publishers and distributors. And that publishers have more of a curative control over what they're saying. And that's why they can be held liable for someone else posting something that would be defamation on their platforms, as opposed to distributors, which is the bookstore. Traditionally, American law had held liable, and essentially, Section 230 carves out to treat these internet platforms and all big tech like they're distributors. And Clarence Thomas, as you all know, and many of your listeners probably know, Clarence Thomas has basically been begging for a case to question this legitimacy. And this is what I want to point out to you that I didn't see come up in that conversation. And this is how I really think, and I'm not making a joke here, I really think this is how we fix the internet. If you look at Section 230, Nick points to that language of or otherwise objectionable, that they're allowed to take content down if they deem it objectionable, right? I'm asking you guys, look, we have four of the greatest minds we could possibly assemble. We've got Eric here, who's a phenomenal judge of talent. We've got three attorneys, one of who is brilliant. The other one is Nick, who's really likable. And then there's me, and I'm creative and brave. So this is my suggestion. Everyone focus on 230C2 and that otherwise objectionable language as being a sort of zone that they can operate with complete unfettered freedom to basically strike down everything. But Section 230C2 also says they have to operate in good faith. And I think that's what Clarence Thomas is talking about, that if they operate in good faith, then they can use the affirmative defense. And it's not a shield, it's an affirmative defense that they would have to actually go to court and establish this affirmative defense applies to them to defend from a defamation suit involving two other parties. And here's the key thing that I've never heard any other lawyer mention on the internet. It's not just Section 230C2. You need to look at Section 230A and Section 230A3. They say the objective there of allowing this Section 230 is to allow an open exchange of political discourse. Now, bear with me, gentlemen, here. If going to Section 230C2 is to allow an open exchange of political discourse, and there's supposed to be acting in good faith, I think Facebook, Twitter, YouTube, and all these big tech giants have clearly been in violation of that, and no one's really tested them on it. And what I'm waiting for is somebody out there, any human out there, to defame me. It could be some random person, let's say, I don't know, Ikne Eketa Ray, might go out there and say something defamatory about me.
Go ahead,
and
David.
I'm telling you, I will prosecute this, and I'll name him as defendant. I have to. But I would also, the key defendants would be Twitter and Facebook and YouTube, and basically make them prove that they're operating in good faith. And I think there's enough evidence out there that we can show that their bias is so tilted that they're not operating in good faith, and they're not encouraging political discourse or free exchange of political discourse, and accordingly that should be shut down.
No.
And I've really been rambling for a long time.
But
that's my thought.
That is the argument, but the other argument is they're private enterprises. They can do what they want under the auspices of 230, which I disagree with. But Candace Owens is testing this now with her lawsuit against Facebook. Who was the one that just sued? And the judge raised, it was against Twitter. It's the computer guy. It's the computer hacker guy versus Twitter.
Yeah.
And the judge raised, sua sponte, issued an order to show cause why 230 doesn't block this lawsuit. So we might get there, and we might get there in that lawsuit. But yeah, there's no question that they have overstepped, in my mind, the bounds of the reason and the wording of the art of the provision. It just takes the right case to get to the Supreme Court. The one in which Clarence Thomas issued his advisory opinion, or his dissenting wasn't a dissenting. His advisory opinion was not the right case. But to get back to Parler versus Amazon, Nick, that judge, we're declining the provisional injunction. If there's ever a case in which you want to reestablish the status quo pending the resolution of the dispute, that was the case.
Yeah.
The reasoning in that decision, it's not to protect my own rationale, my own reasoning, because I was wrong, because I think the judgment was wrong, and someone's going to say I'm as biased as someone else. It was not a politically motivated reasoning. The provisional injunctions, interlocutory injunctions, precisely by their nature, are intended to reestablish the status quo to avoid irreparable harm pending a resolution of the dispute, which would be done on an expedited basis. What the judge effectively did was render a final judgment on dismissing the provisional, because the final judgment became without object. But they refiled in state court. Nick, tell me, what do you think? I mean, I read through it. There was a lot more meat in that bucket than the first federal lawsuit, but some of it seemed like it might have been a stretch just to get as many causes of action out there. But I don't know anything about Washington state law.
Some of it, they have something like 13 causes of action. And I got bored after their first 7. But because they get really repetitive, it's the same cause of action with a slightly different set of facts. And who knows? As you guys all know, typically you're going to lead with your strongest cause of action, and then they're going to get progressively like a little leveling out of usefulness. So yeah, I think they went on a little too long, but some things I'm really, really happy to see in there. One of them I was screaming at you about while you were talking with Barnes during the first Parler lawsuit, I
saw some caps there.
Yeah, it was the Washington state implied duty of good faith and fair dealing. And under Washington state law, you have a legal obligation created by statute to make a contract work to the benefit of both parties. Your duty is to make the contract work for the benefit of the other party as much as for yourself. Now, in Texas and in several other states, you enter into a contract, your only concern is your own value out of the contract. But in a few states, they have this. And in Washington state in particular, that term has teeth. So the fact that they didn't include it in the federal lawsuit was a big mistake, in my opinion. They should have argued that before the federal judge, and they didn't. So she never considered it. But there's no way you can square the idea that Amazon's contract of adhesion, which allows them to say they're going to give you 30 days, and then also allows them to just not give you 30 days for the same exact reason as they would give you 30 days, is an operation in good faith and to the mutual benefit of the contract holders. There's no way you can square that. So the fact that they included that is really, really encouraging.
I have a question for everybody.
I agree with what you said.
Okay. Well, real quickly, because I don't want to get too far away from it. You brought up defamation, Joe. And from what I've been hearing and seeing from all these other crazy lawyers too, defamation doesn't seem to be doing the trick. The only way to draw blood is maybe by proving some sort of contract failure or something on the business side. And I wonder if you guys can all discuss that as well, because I do keep hearing, oh, okay, defame me, defame this, defame that. And then we've had everybody, going for that, but nobody seems to care.
Yeah, briefly, I'll start with this one. I want to say that there is a theory out there. Sorry, Joe. There's a theory out there that I've seen actually advanced in court cases that lawyers are pushing the idea that you cannot defame someone via Twitter, and we see some sort of interesting approaches coming from other types of media on this. One of them was pointed out to me by Nate the lawyer. He brought up the fact that after the Tucker Carlson ruling, it's basically Tucker Carlson's argument on defamation was no one would believe Tucker Carlson to state a fact. And the court was like, yeah. And so it's like, wait a minute, are we getting to the point where we're going to just get rid of defamation as a cause of action so long as it happens?
Wasn't that Maddow too? That she said explicitly, and she said, "Hey, literally. I'm a commentator. I can say anything." Same
right,
thing.
and
she said,
and if we're if we're going to get
literally,
to this,
it's not literally.
Literally,
wait,
not
no,
literally.
Hold on, I'll pause it. Joe, go,
Joe.
Thank you, David. I'm going to hire you as my counsel.
You took too long.
He just keeps going and going.
Yes.
Damn it. No, I just want to ask you this, Nick. Nick, you want to go forward and you want to start saying contract of adhesion. I'm going to ask you this. Have you ever, show off the top of your head, I'm sure you can Google and find an example. Have you ever worked for They seem to just ignore that rule, the contract of adhesion, that you can get out of it. If you want to tell me that maybe have some influence on a case that you can sort of throw it in there as a side factor. But if you're going to say contract of adhesion, that I've never seen that. I've tried it. I've tried bringing that up in American courts. That doesn't. The judges look at you and they're like, they roll their eyes and they say, "What's your next cause of action?" Go ahead. You stood up for me, David. I'm going to stand up for you. Go ahead. No, it's your turn. Everyone else quiet.
In Quebec, contract of adhesions, we have the principle under our civil code that they're interpreted against the party that imposed the conditions. Typically that plays out in consumer contracts, not necessarily in big business with other sufficiently big business. So they're raising it. Parler's raising it in Amazon now, which is interesting. But actually, and we'll circle back, to use the term, to the defamation in a second. But I want to get one question to Nick. In the Parler state case, they are now alleging consumer protection violation, which raised a big flag for me, because in Quebec, consumer protection is only between a business and a consumer. And is Parler purported to be a consumer that would be covered by the Consumer Protection Act? And if they're a business, are they not just going to be excluded from the application altogether?
I don't know the answer to that one. It's a good question. I mean, they're definitely a consumer of Amazon Web Services, right? Like they're in a customer relationship to Amazon in their purchase of in their use of the cloud services. So I'm not sure exactly how it is. The way they defined it in the lawsuit suggested that they were a customer under the definitions in the statute, but I haven't read the statute, so I don't know yet. I'm curious to see Amazon's response to that. That could be in what they say. But briefly to address what Joe was saying, I love contracts of adhesion in American law because every single court says we treat contracts of adhesion disfavorably, and every single decision I've ever seen treats them as favorable and loving as possible while saying the opposite.
Yes.
But they are
Yes.
supposed to be construed against the drafter of the contract of adhesion. So there's at least a legal principle there. But I want to reiterate that I do know of someone who has won an arbitration based specifically on the good faith and fair dealing in Washington State, and this past year. This is a recent win. The way that the arbitrators construed the good faith and fair dealing clause, according to Washington law, was that it is a strong provision. So it's one of the things that I think really needed to be in the federal lawsuit. Again, I think this is almost a foregone conclusion because Parler's dead. There's right before Parler was shut down, I was gaining followers on there like crazy. People were active, they're engaged. You go over there now, it's a graveyard because everybody who had energy on it has moved on. They're trying to resurrect a corpse, and I think that irreparable harm was done already, and it is literally irreparable. I don't think
it's actually proven out why they sued. I mean, they knew they were dead. That's why they sued. Is they needed that injunction to stay on. I mean, knocking them out. I mean, in today's world, 3 days gone, you're gone.
No,
okay,
I can't. The app, apparently, if there is an app, it's not available in my region. I can't seem to log on via desktop. I
have the app. It does work, but only because I had it installed already beforehand.
Well, no, the issue is going to be, they allege in their new lawsuit that they got in what they call vendor lock with Amazon, but the question is going to be, at what point do they become culpable and responsible for their own business decisions to become vendor locked with Amazon? But hopefully it sets a precedent for all other businesses that are doing business with Amazon. It's they don't care.
The other problem, one of the other problems that they face, I pointed this out when I was going through it yesterday, is part of their argument is that Amazon prevented them from getting another cloud service, yet they got another cloud service provider. I mean, they did get one. So they're going to have to prove out that they were significantly hampered due to Amazon's constraints or Amazon's actions. And it's not the strongest argument to say, oh, you got one a month later, but it is true that they got one. And that's going to, I think, mess with part of the, Amazon's going to say, hey, it's a limited market, and they went around and they found a vendor who would support their usage that they wanted to do. Another one that I think is a big problem with their argument is they routinely claim that they offer cheaper advertising, which makes them a competitor because they don't do targeted ads based on personal information. But the logical counter argument of that is that's a different market of advertisers. So you're not actually competing with us because Coca-Cola is wealthy enough and cares enough about where their ads are going that they want the Twitter advertisement. They want the Amazon targeted advertisement. They don't want Parler's advertisement. So those are some of the problems that I have with their arguments.
Go, Joe.
That's a weaker. That last one you gave. I mean, I agree. I agree that could hold up, but I think that's a weaker defense. When you're saying, thank you, David. So when you say that that's a different market, at the end of the day, just because Coca might prefer to Target, that doesn't mean that Coca-Cola, that Parler and Amazon are not competing for Coca-Cola's marketing, and that they are genuinely competitive, even if they might approach their marketing strategies differently. I don't see that argument holding up. What's really tragic for Parler, though, and it's Dan Bongino and whoever else is associated there, is that you are all correct, right? Eric, I think you pointed this out. You're correct. Parler's done. Or Viva definitely said this. Parler's done. They're never going to resurrect the way that they were. It's really unforeseeable. And as far as in this lawsuit and collecting damages, they're cooked because no court wants to give speculative damages, and all of their damages that they sustain, the loss of this company, it's all speculative. How do you know how much they would have made had Amazon let's assume Amazon is in violation here and they could be held liable. Go prove how much they're down. It's impossible to prove.
Well, no, I'd argue it's
so. I think that they're never going to see anything back.
I think that, I mean, if you have a fair, you're going to have a trial by jury if it gets there. I still think there's a strong breach of argument. I mean, the idea that Amazon says we have to give you a 30-day cure period for a termination, but not for a suspension, is an absurd interpretation that basically reads out the notice to cure. So I think,
unless you're Nate, for whatever reason, Nate is like, oh no, that's fine.
Well, he's a smart guy, so you have to respect his position if it's different. But I mean, I've had the argument with him. It's an untenable argument.
Here.
Yeah, it was here. You say, yeah, sure, we can. If it's an urgent enough thing, we can suspend without notice. Okay, maybe. And you take the most extreme examples. You suspend until it's cured, like presence of some type of illegal video, and then suspend, and then
sure, like if the whole thing is spattered with CP, all of a sudden a timeline.
Yeah, then you shut it down, take it down, and then once it's cured, you bring it. Once that's resolved, you bring him back. But the idea that you can indefinitely suspend, tell them to go migrate, you'll help them migrate, but it wasn't a termination and you didn't have to give them 30 days to cure, is an absurd interpretation that can't hold water. The losses are going to be, if nothing, forget prospective future gains, just shareholder loss, loss of value, loss of investment. I think it's a straightforward claim. But where I think they start stretching it a little bit is, and we'll get back to Joe, is they allege defamation in their state case, that they couldn't get servers because Amazon defamed them in the reasons for which they terminated their contract. There, that's a weaker argument that I might not have even thrown in because it might be so untenable. But hey, throw in defamation, see what happens.
I agree with you that the defamation is stupid. And like Nick said, when you have those claims at the end that he put it on a line that goes down, I think they go like this. Down. It's like once you get past like claim number 4, it's like you're just wasting time, and people get and the court gets frustrated that you're just wasting time with claims that are never possibly going to succeed. I still don't understand. You want to say the shareholder claim that maybe that they lost money that was committed to them from shareholders based on this, who got out of the contract. Okay, that's more tangible, provable loss. I just think that, I mean, I've appeared within the past year in front of judges who literally will say to me, I've been a judge for decades. I've never once granted speculative damages, and you need to be able to prove tangible loss. And it's speculative. What's more possibly speculative than the future success of an internet platform? I mean, that's as speculative as you get.
I think there's some provable damages in the forms of, according to the way they wrote this lawsuit, and I want to circle back to Nate in just a minute, but because I want to defend Nate's good character.
No, he's a great guy. We love Nate. He was invited to come here. He said, "Oh, those guys are coming on." Never mind. No, I'm just kidding.
Oh well, now I'm going to change my argument. No, so in this. I think they're, based on how they wrote the contract, it sounds like they can prove out that they had advertising agreements in place, and by being shut down, they're not allowed to fulfill the amount of clicks for the advertising contract, and presumably they did not receive revenue on those clicks. I don't know how much that is. They said that they were making they had millions of dollars in advertising revenue that's lost. Now, I don't know if that's speculative. I don't know if they have an agreement. They're going to have to prove that out. They're going to have to say, look, we had an ongoing agreement with such and such company. For every 1,000 clicks, they pay us $3 or whatever it is. And then this is how many clicks we were providing on this date. Obviously, this is going to continue going forward. Even if we don't say that there was a speculation that more people would join, we cut it off at the 15 million users that we have. I mean, 15 million users with ad revenue, that chalks up to a significant amount of money very quickly. I mean, any one of us would love to have 15 million eyes on every ad that we that runs on our YouTube show. So,
Nick, you pulled a Pasaki.
Yeah.
I have created the graph. It's just going to every now and again.
Nice.
Circle back, people.
But to circle back to Nate, I wanna point out that Nate's arguments were on the original lawsuit. I haven't heard him talk about the new lawsuit. I don't know if he's changed it, but I will say that the claims in the lawsuit that is filed now are much better fleshed out. much more favorable to Parler and more clearly lay out the timelines related to what Amazon knew, what their communications were. And I think it is a critical difference. And I don't fault the lawyers, except I do, who filed the original one. It's actually the two people who are co-signed on this one were the lead attorneys on the other case. But they really didn't have a lot of time to draft that complaint. And when you go back and look at this complaint versus that one, you see the difference a month of work makes over a week.
And so I want to go back and not circle back because I'm not Nick.
Circle back, youngin.
I'm not cool enough, but I do want to address, because there's a lot of people, and I hope I'm wrong, but they're saying, no, it can be rebuilt. It can come back. It can. Look, I've been around for 10 minutes on the internet, and I'm telling you, when something gets destroyed, it gets destroyed. Gab got taken out when the shootings happened, and the problem is they've come back sort of, but they've never really come back. Their momentum was cut off at the knees. MySpace, we're still, MySpace is only mentioned because it's a cautionary tale. Friendster's gone. Hell, AOL at one point was all of the internet at one point. And right now, I just get amused. I'm like, oh my God, that's charming. Somebody has an AOL email address.
So that you can gauge someone's age by whether or not they have an AOL or Yahoo or Hotmail. I know they could read it. I think the difference between Gab and Parler, I think it's a reputational thing. Gab really got branded as something of an extremist alternative
versus Parler getting branded as an extremist.
I think they are, but to a lesser degree. And I mean, look, for all the bad, the good is that this Parler lawsuit really is making people realize that the worst and most egregious actual incitement occurred on Facebook, and coordination occurred on Facebook and Twitter.
Well, the shooter was on Twitter and Facebook and did very little on Gab.
No, it's honest, but it's difficult to build it back. And you're not if build it back better, even if we can use another catchphrase. But for people don't necessarily appreciate, like when someone comes to you and says, I've got an injunction, it's an emergency. The client doesn't have all their stuff together, and they come in on a Friday and say, or maybe this was a Sunday, and say we need to file by Monday. You don't have the details fleshed out. And it's true that in this state case, they fleshed out the dialogue, the email exchanges between Amazon reps and Parler right before the incident occurred, where they're saying, oh, I hear Trump's coming over. Hannity says Trump is coming over. Is that true? And, they're talking about Trump, but they're not talking about incitement. So on the merits, hopefully, maybe they'll get millions and millions of dollars in damages or a big settlement, and they'll start something new. And then they'll just have to find a new app and, become independent. But just to circle all the way back to Joe, defamation has gotten not very far in the States. It gets much further in Canada and the United Kingdom, just because we have so many more restrictions on what you can say and cannot say. In the States, you can basically get away with anything so long as it can remotely be qualified as opinion, or so long as the individual is remotely a public figure. In Canada and Quebec, no less, you can be found guilty of defamation even if what you're saying is factually correct, which is a particularity.
Just to be clear, though, I cut you off in the middle because I knew that you would hear it like 40 seconds later. So just to be clear, I'm not talking about defamation from the server themselves. I'm against me personally or against any particular individual. I'm talking about the vicarious liability that they obtain as a publisher because they're a platform where A defames B. And that's really what I think Clarence Thomas is looking for. You guys are saying that this has gotten nowhere in the courts. It's a matter of you need to keep pushing forward under the proper arguments. If you don't have the right legal arguments and pointing out that this affirmative defense is not a valid basis for dismissal of a complaint against Twitter or YouTube because they don't qualify. They don't qualify for Section 230 protection because they've not been acting in good faith as to what the statute itself is looking for, which is promoting public discourse. Once they lose qualification now, they're a publisher and liable for any defamation committed by any two idiots against each other. So if Nick and I were to defame each other right now, in theory, because they don't have that protection, we could hold YouTube liable for that. That's my point.
Well,
Not
yeah,
the
no,
distributor,
the,
the publisher, and that the terms of 230 itself specifically point in that direction, that they're supposed to allow political discourse. So because they're shutting you down, because you have to wear the monetized shirt, Eric, because of the fact that as soon as Nick puts up a speech by Trump, which is obviously nothing dangerous or hateful or anything like that, they're shutting down political discourse. They're not acting in good faith. They don't have the protection of 30C2, and any defamation between any two people that gets published on their platform, they can be held liable as another publisher. That's my point. And I don't think anyone's made that argument, certainly not bringing up A3 and that the purpose of 230 is to promote public discourse. I've never heard of anyone doing that.
I thought that 230, and I could be wrong on the history, but going back to the 90s when it came about, I thought it was back in the days of the Prodigy and CompuServe bulletin boards. And what happened was that there was a bunch of really awful stuff on the bulletin boards, and they did try to take some of it off. And as soon as they started to take a little bit of it off, they got caught in a snare that they were suddenly responsible for things that they didn't take off. And that's so I don't know that it's necessarily to promote public discourse. I thought it was to protect them in the sense that, no, you are a platform and you can't be held liable for people who are doing it. The what is it? Dershowitz calls the taxi cab thing, where I just drive the cab and take you from A to B. I don't know who you are, what you're going to do, or anything else. You just took a cab, or the telephone. You know, whatever happens on the telephone, you can't be held accountable for it. That's what I understood 230 to be. So that I think some of this is confusing because it was actually put into place for technology that was prior, and we've moved way beyond that with Facebook and Twitter and things of that sort. So it gets hard to define. I'll get to you, Joe. Trust me. It's hard to define exactly how it's to be applied because internet moves on. Go, Joe.
Pull up 230A3 right now and read the intent of it. Read its intent. Just read it out loud for your viewers. I don't know if you could show it on a screen here. Pull up 230A3. You'll see that the purpose of that statute, which is really designed from having that vicarious liability smacking big tech, that the purpose there is so that we can encourage free speech, that they don't have to worry about someone saying something that's going to be, and because they're allowing that. That's why they get 230. Once you're not allowing free discourse, you no longer should be entitled to it. That's the argument that I think needs to be made and brought. And you'll lose in the federal court. You'll lose at the district court level. You lose at the circuit court. The idea is that you want to get yourself up. You want to get yourself up to the Supreme Court and have Clarence Thomas say, yeah, they're not compliant with 230C2 with the basic language of the statute and its intent as stated in the statute, and therefore they now can be subject to any defamation that A commits against B, even if they don't even know it was published. You reading it there? Someone to read out loud?
Yeah, we've got it pulled up. It says the internet and other interactive computer services offer a forum for a true diversity of political discourse, unique opportunities for cultural development, and myriad avenues for intellectual activity. But it's a finding of Congress that is the basis for crafting the law. I don't know that I don't know that a court is going to say that this is a motivational or aspirational goal of 230, as much as they're going to say this is Congress's rationale at the time for drafting the statute as written.
This is a preamble of sorts. It's not
right, because the policy is when they're getting into the actual statement, right, Nick? And I'm dumb on this, so you guys have to keep me in line. That's why I need three of you. I'm triply dumb.
You're correct on that, but it's telling us how to interpret the in good faith part of section 230C2. The preamble, which I agree with you, is not technically binding. That's what clarifies what the purpose of 230C2 does. And 230C2 starts with if they're acting in good faith.
And be sure that I'm not disagreeing with the principle of your argument. I'm displaying my lack of faith in courts to apply it.
Well, and not just that, but because the rationale, the justification is they're removing content that is otherwise objectionable on the basis that it can incite violence by undermining, whatever, faith in the electoral process. So the rationale is not that they're censoring political discourse, they're fortifying political discourse, don't you see? And they're doing that by eliminating the objectionable content that would otherwise undermine the system. That's the rationale. So I'll tell you what,
comment puts it really well. They almost contradict each other.
they do. Well, they contradict what's being done in reality. In practice, the justification being offered for what they're doing is that they are trying to undermine incitement, and they're trying to eliminate incitement and material that is otherwise objectionable that will lead to certain problems. That's their stated rationale, but we all know better. Joe, my only issue, I hate the terms good faith, especially when you get into court, because people throw them around to such a degree that every time someone disagrees with someone, they say they're acting in bad faith. So I think a court, to make a determination on a good faith gesture, it's going to have to be overtly bad faith in order for the court to come to the conclusion that there was manifest abuse in bad faith. So I just think all of those arguments where you rely on good faith arguments, justice is human, and you're going to have some really, really bad faith gestures in order to prove that there was an absence of good faith.
Where I think the hope is for Clarence Thomas or someone else to go after is to really focus on that otherwise objectionable language. I'm looking for it now, but the idea, I don't remember. I guess I could use a Control F.
It's in 230C. It's in 230C. It's in the 230C3.
230C3.
C2. Sorry,
but
C2.
C2. Yeah.
C2.
So here it is. The reason I think that this is attackable is the otherwise objectionable read in context of the statute. The logical outcome is that it's not literally otherwise objectionable to any subjective degree. It's otherwise objectionable as a catch-all, considering obscene, lewd, lascivious, filthy, excessively violent, harassing. So you've got illegal material, you've got overtly, patently offensive material. You don't have latently offensive or subjectively offensive material included in this. You're talking about stopping cheese pizza from being put on the internet. You're talking about stopping real murder videos from being put on the internet. And that's what their entire purpose of this law was. And so I think if we could get the court to narrowly construe otherwise objectionable to be confined to something that's in the same line, that's where it is. But it's having
like high crimes and misdemeanors, what does it exactly? It's
without getting into the political side, the judicial side, you can void for unconstitutionality due to ambiguity. I mean, Nick and Joe, can you not make an argument just to read out to eliminate because it is ambiguous to the point of unconstitutionality, otherwise objectionable because it's too subjective to apply?
I think the problem with a void for vagueness ruling on this one is that the government isn't the one actually stopping the speech. So 230 isn't facilitating the removal of speech, because in theory, a platform could not remove the speech, right? Like they don't have to. So typically, I think when you've got unconstitutional for vagueness, it's that the law as written will cause government to censor more speech than would be otherwise allowable. And so since this one is not actually facilitating a government censorship, I don't think vagueness will apply on it. But I agree, it is
so when
vague.
Facebook and Twitter, when Facebook and Twitter deplatform Donald Trump from ever being able to say another word on their platforms, how can anyone say they're acting in good faith to promote public political discourse? I think that it's not. I understand. Look, we should take a look at the whole Parler situation and how they got killed in federal court when they sought an injunction, and we have to look at that in context. And the context that I think a lot of us might not be thinking about is this: the left successfully treated January 6th like it was the brand new 9/11. And we all have to coalition together and cobble together to protect America from future incitements. And that's why they kept labeling it another 9/11, so they could say this was a crisis averted. We had a new crisis averted from that storming insurrection on March 4th by QAnon that no one ever heard about other than the government. But my point is, in the wake of January 6th, where many Americans, millions of Americans, and promoted by the media and by the left, were saying, wow, we just got saved from a terrible insurrection of our government. So there was this coming together of like, we have to make sure that we're protecting from that. As we distance from the date of January 6th, that need to protect ourselves from potentially insightful language will, that feeling of necessity and urgency to protect from that, I think that will start to shift away, and people will realize how completely fascist this approach has been applied. That's my thought on that.
I'm waiting for Trump to sue Facebook because at the risk of playing devil's advocate, because someone will segment this section and then say Viva Frei said this. The Facebook
might even be me.
Sorry, yeah,
might even be me. Let me zoom in and get.
Facebook's argument, and it's one that's untenable, and it's one that I don't believe in, is that they've removed Donald Trump to avoid further incitement and further violence. That's the rationale. They're not censoring, they're not being mean, and they're not acting in bad faith. They're acting in super duper ultra good faith. I am waiting for Trump to sue Facebook.
It actually sounds like a thought crime. Is that where you're going? That they're saying that they're removing him to prevent this thing that they know, they read his mind, that he's going to do in the future? They're
going to go back to the past and say, this is why we did it, and this is why we're not letting him back. It's not a question of can't trust what he's going to do in the future. What he did in the past was so egregious, it led to an insurrection. Put my quotes up there. But I am waiting for Trump to sue, because I bet he doesn't need to rush to a lawsuit now. It can be more thoroughly thought out and drafted, but his lawsuit is effectively going to be something similar to Candace Owens, but maybe on a larger scale, because they took down an existing account and then prevent one individual from reopening. We'll see. It's totally unjustifiable in my mind. You punish. It's egregious. It is nothing more than big tech showing that they are more powerful than the government. And it sends a signal to all other politicians: don't piss us off, because we can shut you down and you'll never get reelected again. I mean, that's exactly what it is.
Good couple super chats to get in really quickly. Dragon's Treasure, by the way, if you want some good tea, you can go to thedragonstreasure.com/ or not slash, just get some tea and use unstructured and get like a 10-15% discount. It is really good tea. I know Nick drinks it too. And
yeah, if you use offer code Nick, you get 1% off more. No, I'm just kidding.
Oh, there you go. There was a 20-year gap between when 230 was signed and when it became part of the public discourse. Feels like it's a law from a bygone era, and the feelings of whoever's in power seems to hold more sway than written law. I think that's probably true, period. And then somebody else is just saying, is there no one that was alive for 20 years ago when they were in Congress? So see Joe Biden, Nancy Pelosi, Chuck Schumer. Yeah, I think there's plenty of them that were alive. Now, the question is, do they know how to work their own computer?
And there was a guy, one of the drafters of 230 put out an opinion piece the other day and said the law is working exactly as intended and needs to be preserved in the way that it's working. So there's.
Could I make some political predictions as to where that person leans politically? If I'm just going to get into motivation,
obviously he's a conservative, right?
I have some guesses. Yeah.
Everything's working as planned, people. This is what we meant. This is how we meant it to be applied. And when it's one of us caught on the other end, we might flip our arguments.
I think what we need to do, another avenue of attacking 230 and its application, and therefore this gets it back towards what you were talking about, Viva, with isn't this thing unconstitutionally vague? We have to start linking 230 to a governmental action. I mean, because what we're actually doing here with these companies is the government is effectively asking them to police the internet. They are asking them to censor the speech. So there's this obscure sort of theory. I say it's obscure. In most cases, it's not obscure, but in this case, it would be that you can have a quasi state actor, where a private company becomes a state actor for the purposes of a particular act. And the doctrine around this is really tenuous and it's really complicated. So we probably don't have a lot of time to discuss all of it here, but there is a theory that the 230 doesn't do anything other than encourage the removal of some things that the government would otherwise be thinking about censoring. And so therefore it allows private actors to go beyond the scope of First Amendment protections for the purposes that the government desires. I mean, let's be real. Some of the stuff in here, excessively violent material, that's constitutionally protected. Absolutely. You can definitely show a picture of someone's head getting run over by a truck, right? Like there's no law that can prevent you from posting that online. That would be struck down immediately. Yet here we have a thing encouraging businesses to take down that sort of material at the behest of government, because government can't. So I think there's a quasi-state actor doctrine, but I mean, you're never going to get that argument through a district court, and you're never going to get that argument through an appellate court because of how that quasi-state actor doctrine is defined currently. That one has to get in front of a Supreme Court before it's going to have any merit.
Actually, that reminds me, weren't there some letters written from the House to different companies recently asking them to take action? Could that be tied? A classic chilling effect sort of idea when we go back to earlier First Amendment law from the bygone era of the 60s when the political scales were the opposite. But yes, where government is making some notions that they're going to regulate Facebook and regulate Twitter if Facebook and Twitter don't do their bidding. I mean, that's classic chilling effect on the First Amendment. And I can't believe that like newspapers are okay with this. Like that they're the ones like, oh, this is beautiful. Look at what these congressmen wrote. It's like, you idiots. This is what the opposite of what you want. But you know, the news today is in the pocket of a particular political party. And so they really don't care about their freedom anymore because they have their security in Democrat policy.
Can I just say,
go for Joe.
No, after what Nick just said, I said something earlier which I sort of need to retract. Okay, so to all your audience members who might have been here earlier, I'm actually sitting with two very intelligent attorneys. So
Nick is surprisingly smart. It's amazing. But,
Nick, I like the qualifier.
on the issue,
these knives feel great, guys. This is
Nick. There was Robert has been sending me my homework for the weekend, and there's been another class action lawsuit against is it Facebook or Google? It's Facebook for having artificially jacked up the prices of advertising. So I think the distinction that you drew between the inflated prices for targeting ads and the lower price for general ads, we're going to start seeing some lawsuits coming out that are going to be going after Facebook and Google for artificially inflating the price of advertising through their effective monopolies. So that'll be an interesting thing to follow. That was just prefacing the homework that I'm doing for Sunday night live streams with Robert Barnes.
I heard a rumor that he gives you more homework than you know what to do with.
I get like I'm not going to. I'm getting emails, but like Robert is that professor in university who says, "Hey, you have a 100-page judgment to read for tomorrow." I mean, I got the Alex Jones petition for certiorari, antitrust lawsuits. The video that I'm going to do today when we're done here is on the multi-district litigation fee. Nick and Joe, you have to have heard about this in the Roundup lawsuit. Now that they settled the lawsuit for $11 billion, there's an $800 and some odd million legal fee that is going to the lead counsel. And, you know, not a controversial thing. It's just absolutely flabbergasting, and not in a shocking way. It's just, you know, they were entitled to 8% of a settlement, and they got an $11 billion settlement for it.
The law firm's like, we're ordering yachts. We want them to pay up now.
In fairness, I think there were something like 30 lead firms in the case. So you're going to have 800 million divided up among the 30. Then they got to pay their experts, whatever. But that's part and parcel of the homework that I'm working on for Sunday. But yeah, wow. Robert is remorseless with the amount of homework he gives me.
Well, he's got that
how did you find him? How did you find? Yeah, thank you. Eric's right. He has like a giant brain, and I want to know how you manage, because you two separately are like each like 1/4 as effective as you are as a team. It's a crazy good tandem.
No, that's it. I met Robert when I did the breakdown of the Alex Jones deposition, and then I was covering the Nicholas Sandman lawsuits. And I didn't appreciate he was the lawyer in Alex Jones at the time, and he was the lawyer in the Covington kids, not for Sandman. And then we met through the internet, and we made a digital connection. It's lasted ever since.
Wow.
So that was like
love story.
Nate. That's how you met Nate too, right? Nate did a video attacking you.
That's right.
On whatever the subject
it was on my prediction of the dismissal of the case in Covington, which he ended up being right at the beginning, but then less right in due time. And then I met Eric. I met you. I forget how now, but it was through the internet.
Oh yeah, it was before that.
A while back. Met Nick through the channel. Leonard French, Steve Lito, who I still got to do a live stream with Lito, but we'll see when that happens. It's a small legal world on YouTube.
Are you going to retweet my tweet that I pinned? Are you going to retweet it?
I'm afraid to retweet it because I don't want anyone viewing that as a dog whistle to bother Legal. So I may just like it and then put my response in it.
I retweeted it for you.
What was the?
That's the Canadian in you.
Well, I know. No, look, because it's.
Hey, there's a reason he's the Joe Rogan of the group.
It's true.
The world is crazy. When people are looking for things to read into things, they can find it anywhere. Like when I was listening to Tim Pool and he was covering the Alex Jones, saying, do this peacefully on Capitol Hill. And now they're investigating Alex Jones because when you hear dog whistles everywhere, the word peaceful means violent. That's the way it works now.
Speaking of dog whistles, and well, I don't know if it's a dog whistle, but it's just, I'll hijack it to segue. Let's talk about Joe's fine governor. What's going on?
Oh,
I know that you just did a video.
I live in New Jersey, where the governor here is hardly any better than our New York counterpart there. But I think that was a great segue into what I'll ask my two esteemed colleagues here is, if you were retained to be his counsel. Well, you have the two separate scandals he's dealing with, obviously the Me Too issue and also the whole nursing home thing. He's not really facing anything right now on the Me Too scandal, but as far as from a legal perspective, but the investigation here, what would be your outline as to how you want to go forward here? Because I think that's what people who watch us want to know, like, how do lawyers think and what would be your approach in defending from these claims that he's killed potentially, that he's responsible for the deaths of tens of thousands of elderly by sending COVID positive patients into nursing homes and reporting it, which I don't know if there's actually any sort of legal obligation to report properly. I haven't looked into the statutes on that, but I have a question.
I would say the defense is to get accused for sexual harassment and have all the news cover this new subject that you really aren't going to get nailed on. And the primary subject, which is involving deaths and things like that, gets completely overwritten. If I'm wrong, that would seem to be a great way to handle it.
So this is now I'm taking flack. I'm taking flack on my last video, which was Sausagegate, because everybody's saying, I don't care about this. I care about the other stuff, as if the two are mutually incompatible. You can talk about the Sausagegate thing just because I think it's something of interest on its own. The COVID scandal is atrocious. Right. I think his only defense is going to be to rely on CDC guidance to the extent that it might have authorized or even dictated what they were doing, or might have at least sanctioned it in the approval sense and not in the opposite sense. That's it. I mean, other than that, but the cover up afterwards,
but one could be criminal, one can be gross, and they're very different in that regard, I think. And it's like, it's kind of like the whole, I do a lot of statement analysis, as you guys know. And I think you were on with Greg and Scott. And one of the things that people will do in terms of interrogation is they'll start throwing out things like, yeah, I smoked that weed and I feel bad about having the weed in the car. And it's like, we're talking to you about assaulting your girlfriend. Yeah, but and they throw out different things that are just essentially smoke screens. So it's like, oh, we're going to give them that to bite on. And everybody's just biting on it.
Well, Nick, you're going to say something.
Well, I was just going to say, look, maybe I'll be the unpopular guy here, but as a Polak, I always want to know how much sausage women can eat. Like, that's
fair enough.
I want to know. I'm kidding. Cuomo, I watched his stupid apology. It's the worst thing ever. Someday we're going to learn to fire every PR firm that ever existed. They're dead industry. They need to go. They're not prepared for the internet. They're not. I don't know how PR firms still have not figured out Me Too. But the one thing you don't do is what Andrew Cuomo did in the Me Too world. The only thing insulating him on the Me Too thing is that he's a Democrat darling. Like that is honestly, if he is saved from this scandal, he will be the first person to issue an apology where he apologizes for doing the conduct he's accused of in his apology and survives with his job. It will only be because he is a darling of the left. That statement was everything you would never want him to say if you were representing him in a legal case that would follow. So I hated it. I hated listening to it. And the reason I hated listening to it is because I have friends who have made that statement and I know that they aren't guilty, but they still got blasted after it. And so I know that he paid some idiot to write that thing for him, and it's terrible. And we've got to get people to stop doing it. You've got to, if you are a public person of any stripe and you're accused of this, you cannot apologize for how someone felt. You cannot say that you weren't aware that you were making someone uncomfortable. You just say the allegations against me are false. That's it. Yeah. You don't apologize. You don't accept responsibility because you're not responsible for it. And the moment you say something like the allegations against me are false, or the moment you say that there's some sort of merit to it, you have undermined your ability to pursue your false accusers. So that's my read on that one. As for the other scandals, they're obviously much more egregious. I mean, he sent old people to a camp to die. Somewhere in history, that's been a bad thing, and that's still a bad thing today.
Nate pointed that out, by the way. We'll go back and throw Nate a bone on that, but he pointed out that it was the same time that Trump had moved a ship, so there was an empty ship sitting there, to treat people, and so it's not like it wasn't a case of, well, geez, there was just nowhere to put these people. They needed the extra care, but no, you had a ship.
No, and Nate's rationale, or at least the argument was, the ship was downstate, 6-hour drive from, say, I don't know, Albany or something. Well, when you're dealing with in a crisis where you've been locking people down for 2 months, a 6-hour drive to avoid an outbreak, given what they've been doing now to prevent outbreaks, is probably the minimal thing that could be done. I did say the sexual harassment stuff. I do think Cuomo's done for that regardless. People are looking at this like the sexual accusations are a distraction from the nursing homes. They're not. These are pairing together now, and one is showing a pattern of conduct that will be interpreted in the other.
I don't know. I think he's going to slide on the criminal side. I think that, he might be out and all that, but this is a way to say, okay, he's spanked down, but I don't think he's going to really face anything. Probably because other people will get buried as well.
Well, he's not going to face. He may not face anything on the decision itself. From what I understand, I haven't checked the dates on when the CDC approved these measures and when they formally retracted them. So I don't know if what he was doing was, justified or not justified, but was rather recommended at the time by the authorities. I don't. In my mind, it doesn't matter. It's common sense. You don't do it. It's why we had outbreaks in Quebec. It's why Quebec has over 10,000 fatalities from COVID. 80-some-odd% from what the last check were in nursing homes, because that's where it spreads. That's where the protection should go, not that's where the risk should be allocated. But
you mean like Sweden, where they knew, let's just take care of the vulnerable people in the nursing homes and all that, and we'll let the rest of it go.
The flip side argument is going to be that Sweden didn't do all that well compared to Denmark and their neighboring Nordic nations. But no, but the bottom line is, I think the bigger scandal is going to be the cover-up, not the decision itself. The decision itself, people knew at the time. So the question is whether or not they were fudging the numbers in a criminal sense to downplay it, all the while he's wagging his finger at Trump and blaming him for the deaths in New York. It's disgusting through and through. And, focusing on his disgusting sexual behavior, which was caught on video as far as I am concerned, it only builds to the character of the individual who is now being accused of criminal cover-ups of 10,000 plus deaths.
I think...
Are you saying...
Go ahead, Joe.
No. So are you saying that it shows a pattern of narcissism, that he's thinking, I can take this, I can do what I want with this woman, and I'm also narcissist, like I can do whatever I want with fudging these numbers? Like, I'm not sure where you're drawing this this corollary.
Well, I'm saying
So-
the guy's is awful through and through. He's awful through and through. You saw the way he was berating that reporter, talking to the reporter like he's some sort of, like he's a crime boss, like sitting on his desk and saying, "What don't you understand?" Like berating reporters, objectifying women in front of his daughter, and then basically admitting the act and just saying, "Oh, I didn't know that someone would feel uncomfortable." It's all part and parcel of the same person, and success leaves clues, and so does awfulness. So this, I mean, I don't think the sexual stuff is a distraction to absolve of responsibility. I think he's going to get in trouble for both, as he should. It's just yes, as a pure matter of fact, what they did with the nursing homes is as far as I'm concerned, in my opinion, borderline criminal, if not outright, and the cover-up proves it. So it's only a question of whether or not the two-tier system of justice works. They went after the governor of Michigan, and they indicted him. If they don't apply the same level of justice to Cuomo, it's a two-tier system, and I think we all pretty much already know that.
I was going to say, yeah. But besides, didn't they do it in Pennsylvania too? And wasn't the person who advised that currently chatting with Rand Paul in Congress?
I don't know.
The same one who
just
pulled their mother out of nursing homes, knowing
Oh
what
yes,
was going
yes,
down.
yeah. Well,
So-
there's that. I wonder if he's got qualified immunity on any of this stuff. I mean,
Doesn't go for criminal, so it would only go for civil.
yeah.
I'm only repeating what I know Robert has told me, which I had the same question. It's like, okay, fine, qualified immunity for civil wrongdoing, but not for criminal conduct. So if it is criminal,
the question is it criminal? Like I don't know that there's a criminal statute that Andrew Cuomo violated to send people to a nursing home.
No, it would be the cover-up. It would be
the cover-up would be the question there. Yeah, and that's going to be on his lawyers being able to make a good enough argument that the cover-up was not indeed a cover-up, but was in fact them ensuring they had proper data or something like that. Something ridiculous there. But I want to say one quick thing that I got to take issue with something Viva said. If there were any class of people currently worthy of berating, it's journalists. So that's all. Again, mild defense of Cuomo.
I quoted you on that, Nick, but that journalists have finally moved lawyers from being the bottom of the pile.
Yes.
Now you're one up from the bottom.
Up. The only reason I qualify something as my opinion and then tone it down, I don't want to get accused of defamation. I don't want a lawsuit. I'm just strongly suggesting what I think is my opinion.
Yeah. I'm just saying, while they're down below us, we got to kick dirt in their face. We got to keep those idiots down. We got to stomp them into the dirt. We could stand on their heads for all I care.
Joe was going to.
I just got to ask you guys. Yeah, what is the charge for civil liability that's resulting from misreporting the numbers? Are you saying that if he had reported accurate numbers, in theory, someone who could say, I left my mother in the nursing home, and if I knew how bad the numbers were, I would have pulled her out, and I didn't pull her out, and then she died of COVID because she got infected while she was there. Is that the basis of the civil liability you think would attach? Because I'm not sure that it sounds like great causation. Like, where do you have causation here that his actions resulted in the death of any particular individual? I hate to throw cold water on the idea, but I love the idea. That's where I'm questioning how that will hold up in court.
Well, I don't know that there's going to be an effective civil claim against him, because even if you do have that a wrongful death theory or some sort of negligence theory towards towards causing the death of someone by ushering sick people into the nursing home by a government order. I mean, I think in the civil aspect, you're really going to run heavily against qualified immunity. I mean, he's acting in the course of his emergency powers. And to say that he went grossly outside of them when the CDC was offering conflicting guidelines on just about everything at the time, I don't think you're going to get a civil case to stick on him. I think the only hope is some sort of criminal liability on the cover up. But and I think that's kind of thin too.
Well, I mean, it depends the extent. In terms of actual falsifying documents, criminal intimidation, forgery. I mean, there's a number of things that could have been have occurred in the context. We don't know. But yeah, the civil side, minimal. And now that you say it out loud, Nick, I do wonder this flip-flopping advice coming from the CDC, which effectively shields anyone. Now, oh well, we did what we went out and hugged people, so we told people to go out and hug people. We told people not to wear masks. When you have this
like Fauci advice,
diametrically opposed advice coming from the CDC, it makes any civil lawsuit impossible afterwards.
And you're both right on that. But what I'll say, you're both correct in that the CDC can be used as a to create a shield for them to use to defend that would not defend the wrongful reporting of numbers. But I don't think the wrongful reporting of numbers is going to open up any sort of civil liability for the basis that that Nick was sort of touching on now. Or really more that I was really saying.
Well, could it have?
But
maybe in the sense that if you're reporting you have less of a problem, resources that could be used to help people have been directed elsewhere. Maybe it could be a causality in that.
I think it's just really. I think it's a really hard civil case. I don't know that they're going to get a civil case to stick on it. What they need to do is everybody needs to look at what he did, realize that it was absolutely disgusting, realize that he condemned tens of thousands of New Yorkers to die, and then and act accordingly,
and then blame Trump.
No, you cut me. Hold on, real quick. I have to say it before it's incitement. Act accordingly at the voting booth. I do because I need to make sure that gets out there. I'm not an advocate for political violence in any circumstances ever. So I do really mean act accordingly at the voting booth. This guy,
even better. If you can recall him, if there's a mechanism in place, that would be ideal.
Yeah. No, it is. I've got to tell you, it's the worst act of war. Is it happens all the time where you actually where one party literally circulates pictures of the victims of their violence, claiming those to be their victims of the adverse party's violence. That is exactly what Cuomo. I mean, first of all, it's what propagandists do during war all the time. It's the worst thing ever. It is exactly what Cuomo did when he's sitting there wagging his finger at Trump, blaming him for the death, saying you better have an army when he comes to New York. He is knowingly responsible and hiding the fact that he's responsible and hiding the degree to which he's responsible for the deaths of over 10,000 people. It's repulsive. And just to go to the comment up here, where was it? It's an avatar. It said, "Pay no attention." He said something about boobies. It was a beige avatar. Oh, come on. He said, don't worry about the grandma. Here we go. Zeno the Stoic. Pay no attention to him killing grandma. He touched boobies. No. You can pay attention to both of them. And as far as I'm concerned, the longer both stories stay in the media, the more attention it's going to get. No one is talking about ignoring one act of evil for another lesser degree of wrongfulness. And the longer they stay in the media, the more comes out.
Here's the thing, though, David. I'm concerned that it's given a mechanism out there that the press will care about. The press don't, or I feel, in my opinion, the majority of press don't want to go after him about the nursing home stuff because they can be accountable too, because they gave him the Emmy or they supported that and they fawned over him. Every time you beat him up on that, they're beating themselves up because they held him up with such a high esteem. But if they can focus on the sexual harassment stuff, then they can just go nuts. Hey, we didn't have anything to do with that. Oh my God, look at this guy. Oh, this guy here. I can't believe that. And that, I feel, is the reason that you're not going to see it, is because they can use it as an out. And that can just kind of quickly be pushed along because they share responsibility too in amplifying his disgusting message.
I'll just say, who was it? Go for it. I've been talking too much.
You go ahead.
I was just going to say one thing. It's Parkinson's law of mundanity at a political level. Parkinson's law of mundanity, you talk about how to restructure a company. The discussion in the shareholder meeting is going to last 5 minutes. Talk about where you put the water cooler. Everyone's going to have an opinion. One of them is easier to understand. There's no doubt the media is going to harp on the sexual misconduct allegations. It's easier to understand. It's easier to sell, and it's easier to explain. The granny death, the deaths of the old people is going to be tougher to explain. It's going to be tougher to correlate, and it's going to be tougher to flesh out. So obviously, simplicity being what it is, they're going to focus on one. And it's not up to the press anyhow to go after him for that. It's up to Department of Justice. And if they don't, then you know that there's a problem, and the press is part of the problem, but the government is also
Right.
part of the problem.
Well, the press, if the press don't go after it, the Department of Justice can conveniently ignore it because there's nobody out there saying, hey, look at this, look at this, look at this, look at this. And that is the problem. And that's part of why I keep harping over and over and over. I think that's what's happening is hopefully people will say, no, Eric, you're wrong. And you'll be proven right. And then it will go after him because that's what I want. I want this to be explained, explored. And
What I hate is agreeing with Viva that it's somehow more complicated to explain that Cuomo sent old people that were infected into a nursing home to die and kill other ones. Like that's somehow harder to explain than Cuomo made some jokes that, you know, probably were semi-workplace acceptable 20, 30 years ago and aren't anymore because the society has changed and the social zeitgeist and the interactions between men and women are different, largely because of this massive social media interaction. Like it's actually funny because what Cuomo does in the sexual harassment context is much more difficult to explain, in my opinion, like from a logical standpoint of why saying a joke is somehow like so egregious that someone should be fired. To me, that's more, but I agree that for the media, it's much easier to say it because they just accept the narrative. Like, oh, he said a joke or he said a thing and that's patently offensive and therefore he should never be able to work again because anyone who says something that offends you should be removed from society forever. But let me talk about how complicated it is to explain that he shuffled a bunch of old people into nursing homes to specifically kill them and other people. Like that's such a simpler concept to me, but I agree that where we are now, it's like the more complicated thing is explained away simply. It's weird. I hate it.
So
Well,
I'll ask you, gentlemen, and I'm really asking you more than the other two, Eric, because this is really more your field, I think. Why do you think the media is reporting this story as much as they are, rather than doing the whole Hunter Biden, let's bury this and never talk about it? It seems very strange because he's such a media darling, and this is how much of a media darling he is. I haven't really heard people really talk about this so much. When they were praising him for his defense of COVID, he would literally take Donald Trump's press conference speech, reword 3 words from it, repeat it 4 hours later, and the media would say Trump is killing people with coronavirus and Andrew Cuomo is our hero.
And
When
look
they would
at
say the exact same words.
leader. This is a leader.
Yes.
If he could only
He
join
wrote an
the
autobiography.
race, we don't. Oh my God, we've only got Biden or whatever. Is it too late for Andrew Cuomo to run? Could it happen?
And
could Chris support him?
Why would they bury him? Why not take this story and do a Hunter Biden with it? It's like, unless he ticked somebody off in the wrong way, somebody
His
powerful. I
usefulness
can't
is
believe
done.
it's.
His usefulness
Is that what you
done.
think it is? His useful.
Oh, completely.
Still.
He is no longer useful to them. I mean, how useful is he anyway? He's New York, for God's sake. You'll notice they're also going after the progressives. You know, AOC, she's a darling right now because she's enough of a, well, I consider her to be an influencer, honestly. She is no more than an Instagram influencer than she is a politician because she's not competent in my mind to be one. But I think that if she was just run of the mill or standard, she'd be out the door too. We don't care about her because they're annoying too. You'll notice they're starting to go after Antifa. They're starting to go after some hardcore leftists too, because they're no longer useful.
And well, without having Trump there as a rallying cause that we have to defeat and slay the dragon and impeach 45, now that that dragon's gone, the natural infighting that happens in the left is all that's left, where it's like,
right, well, who's to
different
defeat?
groups
They have both houses. No, they've got the Senate, they've got the House, they've got the presidency. Who's there to defeat?
Yeah.
Well, the running theory, this is from Barnes, and I see it in the chat, is that they're politically taking out Cuomo because he was the only competition to Kamala, and so now this is how the infighting works. So I mean, I don't know, but
thank you, Robert.
Yeah, no, and you know, I mean, I don't know. I just don't think either of the scandals are going away, and
no, he's done.
But it is. I'd say why it's more complicated with the old person, the long-term healthcare facilities. You got the CDC defense in theory. You got other states did the same thing. You got the we didn't know, blah blah blah. But if the cover-up is what it sounds to be, everybody knew, and they should all be held accountable.
All I gotta
And
say
I'm
is
gonna
that
go
if,
against the prediction. Sorry, Nick.
all I gotta say is if Cuomo hires Kevin Spacey for his PR team, all of his accused need to take out life insurance policies and move out of the country quick.
Oh man,
Oh.
Kevin Spacey, Mr. Forehead.
Suddenly, Andrew Cuomo comes out and says he's living his life as a gay man, and all of his accusers end up miraculously dying within a year. It's
I'm gonna disagree with all you gentlemen here. I'm gonna be bold and I'm gonna say my prediction is we've never seen anything that happens in an odd number year that actually affects a politician. Nothing that happens in 2021 affects a politician in the voting booth, and that's why I'm telling you my prediction is.
What about Spitzer? I think his was an odd.
Was it really? Yeah, but
I have to look it up. Sorry.
And now you got that's interesting.
It has to be the odd year.
I'm going to tell you. I'm saying it's not an election year. People have very short memories. I think that even if he gets thoroughly embarrassed in these scandals, I'm telling you, I think he'll bounce right. It'll just be water off his back, and they'll be focusing on other issues come election time. And I don't think this is going to have very significant impact on him unless he does more PR mistakes and messes up further, where it becomes an ongoing scandal. But I think that this is something that's really not going to long term affect his political future. It's stupid. It's pathetic because I think he is responsible for death. And I'm going to go to you in a second, Viva. I'm not forgetting about you. I see your finger there. But I think it's stupid because he's a vulgar creature. He's a narcissist. He does sit there like he's some new part. He's a new player from The Sopranos, and he sits back there and basically talking about calling Vinny over here and bring me that chick and give her a sausage. I mean, he's disgusting and he's evil. But I still left. I think he'll. I'm banking on him that he's going to bounce back from it. That's what I'm telling you.
I'm gonna take the. You've heard it here. 1 hour 26 minutes in, Cuomo is done for, and it's going to get worse. And now that he is such persona non grata, stuff is going to start leaking. More damning stories are going to start coming out, and more damning documents are going to start coming out as relates to the nursing home scandals. And he's going to be more done for than he is done for as of today. My prediction.
I'm going to double down on this to cause more depression. Cuomo is finished, and de Blasio is going to rise up to take his place, and we're going to go from
he won't.
bad to worse.
That will never happen. De Blasio's done.
Nobody likes de Blasio.
The guy killed a groundhog. He killed a groundhog. He's done.
And they covered it up. They covered up the death of the groundhog. This is
yes.
You know what? Oh God! Anyhow, I did a video on that too. No, the death of the groundhog.
Okay.
The two of them buried New York City. New York City will never bounce back from what they did with these lockdowns because there's no reason. I live 10 miles from the city. I have no reason to ever go into New York City. After they set everyone up to be operating on Zoom, the expense of renting or leasing property there, the restaurants have all shut down. Hundreds of restaurants closed. They can't just, and people will think, and this is a mistake when it comes to restaurant industry in particular. People think, oh, one restaurant closes, another restaurant will open up next week. No, the benefit that they had there is they would cluster restaurants together. So you're walking down an avenue and you're basically saying, oh, you want Italian, you want Chinese, you want to go for Asian, whatever it is. It's pizzeria, new prime rib place. The clustering was made New York special, and that's gone. There's no reason to pay the price of going into New York. I can sit in my underwear doing whatever I would do in an office in New York City. Why would I pay, tens of thousands for a lease per month? No, and everyone's realized it. And that's why I'll tell you that New York City is far more done than Cuomo is. And I pray you're right, Viva. Okay. I mean, I'm praying that you're correct. Cuomo is awful. I pray you're right. I just fear that the devil survived.
Well, on this happy note, New York is going to fall off into the Atlantic Ocean. Hopefully, California can join it into the Pacific Ocean. We'll move on. Everybody, please consider subscribing. I know we've got...
second, Eric. I didn't do it yet. 811 people watching. I don't know how many thumbs up there are. Everyone should have already thumbs up, so there should be 800.
I'm only at 410, man. 410.
Oh, no.
There needs to be more.
There's
more likes.
And
guys,
subscribe to Eric Hunley.
Subscribe. Please
and
subscribe.
Joe Nierman. I don't know what your channel is, Joe.
Eric is awesome. Good Lawgic. Good Lawgic.
And guys,
not Logic.
Guys, throw him some support so he can get some good equipment. And he can
not be
seriously.
I'm still trying to get
it's
4,000 hours. I'm still.
Yeah, but-
it's crazy. My hour time clicker is running backward.
My question is, did Cuomo send your internet signal to a nursing home to die? Like what the?
Well, I don't know. It might be his equipment belongs in a nursing home because it's so old.
Oh, I'm gonna mail you a laptop or something.
Hold on. Say Sean McDonald.
God bless you.
Good Lawgic, Viva Frei. Can understand for a variety of reasons why you wouldn't, but given the places you live, you guys honestly thought about moving. I'm thinking about moving. I'm not. The thought is going through my head because Quebec is just going off the deep end of the dictatorship cliff. It is what's going on in Quebec is nuts, and now we're still under curfew, and we had like 600 hospitalizations in a province of 8.5 million, and now they're talking about the variant to justify continuing these. I'm nervous that Quebec as a province is going to turn into a ghost province because nobody can put up with this forever.
Look, if you want to move to
Hampton,
somewhere,
Virginia?
if you want to move back, if you want to move somewhere that's just as communist as Quebec, my other house is for sale. Just let me know.
Where is that? Is it in Minnesota?
Yeah, it's right by me. You can come hang out.
My accent would go unnoticed in Minnesota at least, but I will see. I don't know. It's no joke. Florida and Texas are looking like oases in a sea of fascism.
Is that where you were thinking about? I know you like to.
I'm not. I can't go anywhere.
Wait, you like ice fishing? Go to South Dakota. Like you want that more free than Texas and Florida. Kristi Noem showed up everybody. The only state with no mask mandates, no lockdowns. Not a single business was told to close in South Dakota by the government.
Unbelievable. No, I mean, I want to go to Iceland, but from what I understand there, like a container of orange juice costs $15. So I'm going to have to start making more money.
Yeah, you need more super chats than that. I'll super chat you an orange juice.
We'll vlog for food.
Folks, you got to subscribe so you can see these guys come back. And we can do it again and boil another ocean. And once again, everybody knows
I will have
Viva
better
Frei. Yes, help Joe. Please help Joe. Joe needs
send Joe some fiber optics.
Yes, please help.
We'll just send him. Just send all your messages.
Viva.
Just send your super chats
I'll
in
send
cash in a
signals.
bottle to Joe. Throw him in the Atlantic Ocean with a corked bottle. A super chat for Joe.
Hashtag please help Joe. And on that, everybody, please subscribe. Thank you all so much. And